Hi, I'm Jim Bush, a partner at Keystone Law Group, a probate firm in Los Angeles. I'm here to discuss with you whether a decedent's trust can be contested. When a decedent's trust does not reflect what their family and friends knew to be their true final intentions, it can be both frustrating and disheartening, as nothing can generally be done to change the trust once it becomes irrevocable upon the settlor's death. Nevertheless, a trust can be invalidated through a type of legal proceeding known as a trust contest if certain grounds exist, which I will go over shortly. It's important to note at the outset that a trust cannot be contested simply because you're dissatisfied with the inheritance you were left. Conditions must exist that call the validity of the instrument into question. Also, only parties with standing can bring a trust contest. Standing means that you have a financial stake in the outcome of the matter. The parties entitled to contest a trust generally include trust beneficiary or the decedent's intestate heirs, who generally are the decedent's family members who would take the decedent's estate if the decedent did not have a will or a trust. A party is generally considered to have standing only if a successful trust contest would secure them a larger inheritance. If their inheritance would remain the same or decrease as a result of the contested trust being set aside, they may not have standing. A duly executed trust carries with it the presumption of validity. Therefore, to successfully challenge a trust, the contestant must have valid grounds for bringing a contest. Grounds for contesting a trust may include allegations of undue influence, elder abuse, lack of capacity, fraud, forgery, mistakes, or revocation. While many of these grounds don't require an explanation, I want to go over a couple of those terms, since they come up often in the context of probate litigation. Undue influence occurs when excessive persuasion is used to convince a person to act against their own free will. For example, undue influence might have taken place if an adult child moved in with their elderly parent toward the end of their life and persuaded them to disinherit the rest of the family and leave them everything. Lack of capacity simply means that the decedent lacked the amount of competence legally required to sign their trust. The level of capacity needed to sign a trust varies depending on its complexity. The more complex the document, the greater level of capacity needed to sign it. Finally, fraud occurs when a person intentionally uses deception against someone for personal gain. For example, fraud might have occurred if the decedent changed their trust to leave all their assets to a family member who lied to them about being financially unstable. Many clients are curious about whether they have to contest the entirety of the trust if they only find certain sections problematic. The answer is yes and no. If there are valid grounds for contesting a trust, logic would generally dictate that those grounds apply to the entirety of the document. For example, this may be the case if the basis for the contest is that the decedent lacked the capacity needed to sign the trust. However, there are circumstances that may enable a contestant to only challenge certain portions of the trust. If the decedent signed an amendment to the trust that modified specific gifts left to certain relatives or friends, the amendment can be contested without involving the original trust in the contest. The last thing I want to go over are no contest clauses. Before deciding whether or not to initiate a trust contest, it's important to be mindful of whether or not the trust contains a no contest clause. When a trust contains a no contest clause, it essentially means that if you were to contest the trust and lose, you could be disinherited. Lately, however, no contest clauses have become more difficult to enforce. So if you have a valid reason for bringing a contest, the no contest clause might not be enforced even if you lose your contest. Because contesting trusts with no contest clauses can have severe repercussions, it's recommended you consult with a lawyer before starting litigation. This concludes Keystone's video on whether a trust can be contested. If you continue to have questions, schedule a free consultation with our experienced probate attorneys by clicking on the link in the caption. Lastly, be sure to subscribe to our channel to be notified when new content has been posted. Thanks for tuning in.